When an accident case comes in, we have to look at the circumstances of the case, and sometimes, in some cases, we have to look beyond what just appears as a superficial matter. As an example of that, we want to know, in many cases, if the driver of the vehicle that hurt you was on the task or on the errand of an employer. If that's the case, in many instances, the employer is also responsible and liable for the damages that are caused by his employee. The theory of that is that if an employer hires somebody and does the work of the employer, that benefits the employer by promoting his business and increasing his profits. And the law, in its experience, looks at this situation and says, if the employee can bring a benefit to the employer, in those cases where they cause a loss, the employer also has to stand behind that. He can't take the benefits and leave the burdens to one side. If an employer is going to have an employee promote his business and bring him profits, the employer must be responsible for both the benefits and the burdens that he creates. That includes compensating people who have been injured by the folks who might be driving on behalf of their employer. And for example, I once had a case where a young man on a bicycle was run over by a lady. We investigated the case. It turns out that the lady was on the way to the bank to make a deposit for her employer, which was a pizza company. As a result of this circumstance, we in fact dropped the case against the lady who was the driver, and instead we substituted as a defendant this big pizza concern, which everyone would be familiar with. And this, I thought, made the case stronger and more attractive to a jury. When you have a corporate defendant who's responsible for the harms that they might cause through their employees, it resulted in a better result from my client. So it's important to know who's responsible in every case.